Okay, welcome back. Our next panel is called Ransomware Slams Europe, Best Practices and Pitfalls for Corporates and Other Organizations. And I don't think that title is an exaggeration. Our next panel will walk us through that, though. Let me start with our moderator, Rubin. He is a senior managing director at Ankura, based in London, with over 23 years of global Big Four and boutique experience to help clients manage complex cyber and tech challenges from the boardroom to the network. His global experience spans virtually every industry: insurance, retail, private, investment banking, private equity, and so on. So no matter what kind of breach, Ryan is the right person for the job. He's coming to us from London, I believe, today, right, Ryan?
Yeah, that's it.
All right, well, welcome, and great to have you with us.
Thank you very much. Glad to be here once again.
Next, I'd like to introduce Rob Dedman, former and first head of enforcement at the Bank of England Prudential Regulation Authority, and now partner in the Special Matters and Government Investigations practice at King & Spalding. Among other issues, he advises clients on the regulatory and other implications arising out of data breaches and cyber incidents, both in the financial industry, financial services industry, and beyond. Rob is in London right now as well, I believe. Welcome, Rob.
Certainly am. Thanks, Bruce. Pleasure to be here.
Finally, not in London today is Emilia Garlicker, who's a partner at Perkins Coie in the Privacy and Data Security Group, and she counsels companies big and small on privacy and IR. She's a highly experienced and well-credentialed cyber lawyer with experience managing internet enforcement programs for platform clients and addressing spam, scraping, and other online misbehavior. Amelia is out of Seattle, Washington. Welcome, Amelia.
Thank you. Great to be here.
Okay, we are hopeful that our longtime panelist, Brett Padres, will be able to join us. He's a Group VP of Unit 42 Security Consulting. If he can make it, we will certainly add him in immediately. Brett will be a great addition if he can make it. But for now, Ryan, let me turn it back to you.
Hey, thank you very much, Bruce, and welcome everybody. Glad that you're still with us after a long day, and I hope you enjoy the session. So yeah, over the last 12 months, the ransomware pandemic has spread across Europe, and its impact has been felt across a number of companies around the region. Whilst the response is often very similar to what you guys might experience in the US, there are some nuances and what I'd like to describe as European variants of the attacks that need to be addressed. And the playbook for these is something that sometimes is fairly unique within the European context. So what we're going to be exploring over the next 40 minutes or so is just some of these nuances, some of the similarities. We're going to be sharing some best practices, both from a legal and regulatory perspective, as well as from a technical perspective. And I'm very excited to have such an esteemed panel with me here. I always talk about cybersecurity as a team sport, and requiring a few different disciplines to really have a big impact. So what we're going to do is start the session off with a discussion around the long tail of ransomware response. This is a session that Amelia is going to help to lead. I guess just to set the context, we're all very well aware of the short-term pain that we all go through in helping a client to recover from a ransomware attack on the IT front, reporting to the regulator, which sometimes isn't short-term. It can take a bit of time. Booting the bad actors out if they're still in the network, and in some cases still going down that path of paying the ransom. However, beyond this, there's a lot of potential legal risks that remain and that need to be dealt with, including the big elephant in the room, which is around notifications. So, Amelia, I'd like to ask you to step up to the podium and share some of your experiences in helping international clients better prepare for ransomware attacks, specifically from a legal context.
Sure. So I think there's three things that I would say in terms of preparation. And some of these are, common to all companies that do this. Some are particularly important if you've got an international footprint. But the first of those is to make sure that your incident response plan or at least that you have a version of your incident response plan that applies to your enterprise, that you're not relying on a siloed plan that's developed through your security team. Because while their immediate response is really important, in ransomware in particular, you're likely to have an incident that has immediate implications for your public-facing communications, for your risk communications with your insurance company. Your executive leadership may need to know immediately. You may have significant operational considerations, and it's preventing you from doing your work. So the enterprise response plan creates a common language, it creates a common team, it creates a way for you all to communicate, and it creates a structure in which you can not only discuss, but create consistent communications, a consistent way of thinking about and dealing with the attack. And doing that ahead of time, of course, makes all of that much, much easier than trying to do it in the middle of wartime. And within that, it's ideal to create that as a privilege structure. And largely that's a kind of US, UK concern because of the heightened potential discovery obligations in a ensuing lawsuit. But what that does is it kind of centralizes the plan and the escalation procedures. You make sure that the team members understand what privilege means and how to restrict their speculation, restrict the creation of documents so that you've got consistent communications, ensure that your counsel is retaining vendors when that's helpful and useful. Because even if you're not worried about necessarily the privilege as a kind of US concept, you still want consistency in your communications. You still want a team that is focused on kind of one response and not all doing their own separate thing. And then over all of this, practice that plan and find those weaknesses. It's especially important with ransomware because it's not just a security issue. It's not just a notification issue. It's an operations issue as well. And so you've got to think through a number of issues that wouldn't necessarily come up in a more straightforward breach. How are you going to get your backups back? Do you have offline backups in case those were your regular backups were infected? How are you going to communicate with customers? How are you going to communicate with the public? And practicing helps you not only realize that all those questions arise, but figure out how you're going to deal with them, figure out what the escalation procedures are, and find the weaknesses. Realize that this particular scenario could be is terrible. They're all terrible, but that there might be ways in which you can head off some of that ahead of time, and then you've saved yourself not only the benefit of practice, but you've helped prevent some of the consequences of a separate kind of breach.
Excellent. Thank you very much, Amelia. I like the concept of the practicing. That fits in nicely with the sports analogy too. I will remember that for next time. As a litigator, do you have any perspectives on what companies could be doing to reduce their litigation risks that might arise as a result of a ransomware attack? Specifically thinking about a ransomware attack on a client that has multiple jurisdictions.
Sure, and it's too easy to say, but obviously the easiest way to avoid your litigation risk is to not have the breach. But it's within that to think about part of the practice is thinking about minimizing the data that you've got that's potentially accessible in a ransomware attack. Attend to that unstructured data. What do you have in your email? What do you have in your server, in your kind of document servers? Because those are the most painful incidents that I've had over the last couple of years, is the ones where they're into kind of an unstructured data set and it just takes months to figure that out. Continue your kind of human error training, your phishing training. Think about logging, because ruling out access to that unstructured data in particular can save you a lot of effort, and it also saves you time. And one of the ways in which you avoid kind of making your potential plaintiffs mad is being able to go faster out of the gate, to notify faster, to be more transparent. So, in the United States, it feels like, any breach with more than, 500 people in California with a reasonably large company is almost a guaranteed lawsuit right now. That's particularly true if you've got really sensitive data. So, if you lost social security numbers and it's your fault, those numbers are regulated by the CCPA, and the CCPA provides for individual statutory damages. And that is just catnip right now. So it's very hard to avoid that if that's the situation you're in, because those postings are public in California, and that list is being reviewed kind of regularly. And so if you are in that situation, there may not be too much you can do. So avoiding it in the first place is a good idea. But as I said, going out kind of faster, not to the detriment of having accurate facts, but making sure that you've got a narrative that makes sure that you are doing your due diligence. And then also kind of thinking carefully about the record you're creating, not just because you're trying to spin what's going on in public, but if you're going to get sued, think carefully about your experts and how you've retained them, and what kind of report is coming out of there. Do you want a report that will be disclosed to regulators and to plaintiffs, or do you not want one? Do you want one that's specifically for your counsel? And those need to be retained and drafted in different ways. And that law, as I'm sure has probably come up today already, is changing rapidly and is really complex and is worth a conversation at the beginning, because you can't kind of sprinkle pixie dust on it later and have the report be privileged. It's something you've got to think about. And companies have gotten it wrong in very high profile ways lately. So it's something to think about ahead of time.
Excellent. Thank you very much. And I know as a forensic company, we've been watching very closely what's been happening with the privilege and how some of the reports that have been produced by companies like ourselves under the auspices of privilege have become disclosable, depending on how they're engaged. Rob, I'm quite interested in your perspective on class action lawsuits in the UK and where that's going, because I understand that there is something happening in that space, and also maybe when we talk about privilege in the US and privilege in the UK. There are slight nuances and differences, which perhaps you may briefly want to talk about and share with the audience.
Sure, thanks, Ryan. I mean, just before actually I go to that, I want to pick up one thing that Amelia said, which I think is a really important point around the practice side of things. So making sure that you have your plan, but you actually execute the plan in peacetime rather than in wartime. In the circumstances where we've come across the plan that's not been executed in peacetime and practiced that way, what we tend to find is people under stress make bad decisions. And people are under stress because they don't exactly know how that plan is going to play out in reality. So there's a cultural overlay, if you like, a sort of business cultural overlay to the practice process, which is really important. And so that everybody knows what their roles are, everybody knows how they're expected to behave, who's doing what. Because when it gets to the crunch and you have a ransomware incident, it's actually really easy for all of that just to go straight out the window. And that's more likely if the plan has never actually been dusted off and tested in the way that Amelia was describing. That's a really, really important point that she made, of a number of the really important points that she made. On the class action side in the UK, yes, that is a thing over here. It is increasing all the time. We're increasingly seeing potential class actions for large-scale data breaches, British Airways being an example of that. And you may have seen in the press that was settled some time ago. So yeah, that is coming over here. It's nowhere near the level that it is in the US. Those of you in the US are very familiar with a very, very active plaintiff bar and a very, very active class action regime. I think we're some way behind that, but I think we're catching up. And so you do have to start thinking, and certainly when we're talking about these things to our clients, we advise them to start thinking very carefully about, if they've had a data breach clear, about the class actions that may come in the US, but also the ones that may come in the UK as well, where there's significant UK data involved. Privilege, I feel a little bit like the beginning to A Brief History of Time, where Stephen Hawking wrote that every time he quoted an equation, he would lose half the audience. And I kind of feel like actually every time I explain what legal privilege is in the UK, we might lose half the audience. But suffice it to say that the key thing in relation to privilege to note is that US and UK privilege are not the same. They don't apply in the same circumstances. They don't apply in the same way. And in particular, they can be waived or not waived in different ways, depending on where you are. And so what we very often have to do, and this picks up another really important point that Amelia made, we very often have to do in these circumstances is to talk very early on about how that privilege issue may play out, both in the UK and in the US, to make sure that we cover ourselves and our clients appropriately in both jurisdictions, because it's very easy to fall foul of one jurisdiction or the other if you're not thinking about that from the get-go.
Right, and I think that comes back to the planning and pre-planning and scenario, and basically carrying out these scenario tests, which should pick up the fact that, oh, do we need privilege or not? And thinking about that well ahead of time, would certainly help a lot of organizations. I think the same thing applies to strategies around reporting and who the appropriate authority is going to be when it comes to GDPR reporting. Because once again, in a breach scenario, it can be, you don't want to be thinking about, okay, I'm a business that's based in the Netherlands, I've got clients in Switzerland, I've got clients in the UK, I've got clients in Singapore. If I were to have a breach, who am I going to contact first? And so I think there's, again, doing a lot of this upfront thinking around risk management ahead of time will certainly save people a lot of pain later. Excellent. All right, so what I'll do is maybe, Rob, keep you on the hook for the time being, and just talk a little bit about some of we talk about the topic of ransomware, and what I noticed that 3 days ago, OFAC have recently updated their guidance on potential sanctions for companies that are paying ransomware. One of the kind of open questions that we have here in Europe is, in the absence of an OFAC, where can companies go, and what should they be thinking about when it comes to making ransomware payments?
Yeah, it's a really important point, and this is moving all the time. And I think the old days of the sanctions authorities not being particularly interested in this side of things have gone. I think we're moving into a new and potentially slightly more dangerous arena for those who have to, or think they have to, or want to have to pay ransom to release their systems. I mean, I think the key thing in Europe is there is a sanctions regime for cyber. It has been little used, frankly. There have been some designations made under that regime, mainly in relation to sort of large incidents like WannaCry, and they tend to be related to Russian, North Korean, and Chinese based threat actors. But the interesting part of that is that the Brexit hasn't really put a hole in that from the UK perspective. So the UK has more or less followed the EU in bodies that and the individuals that it designates in relation to these sorts of cyber sanctions. So from that perspective, between the UK and the EU, there's not a great deal of difference in terms of who's on the list, and not a great deal of difference in the regimes either, actually, in reality. They're not hugely well enforced at the moment, so we don't see a lot of enforcement activity in the EU or in the UK around these sorts of sanctions. We've seen a bit in the UK from a banking perspective, not cyber related. But certainly the level of fines and the level of activity that we've seen out of OFAC in recent years has not been replicated in the EU in the same way. And so quite often when we are talking to our clients around these sorts of issues, the OFAC side of things tends to figure more significantly, if I can put it that way, in the conversation than the UK and the EU does. Not to say they're not there, they are, but enforcement is everything in that context, and OFAC clearly carries a great deal more fear for clients than the UK and the EU regimes in their current form do.
Great. It actually reminds me of a case we were working on with a client who did challenge us on this and said, look, we don't have any operations in the US. Why should we even bother with the OFAC rules? And we had to remind them that their insurer is based in the US, and if they did want to get any form of support following any kind of payments, that they'd be asking the questions, and if not the insurer, the reinsurer. So there's definitely obviously a very key link there, and at least they have set a precedence that others can follow.
Yeah, and you do need to think very carefully about that. I mean, and the UK and the EU are no different in that context, in the sense that if you directly provide financial support to those people who are designated, obviously you commit an offence. But equally, if you indirectly provide that support to those individuals or designated persons, you commit an offence as well. So the same issues arise here in relation to insurers potentially being caught by those sanctions, even though they're not directly paying the ransom to those threat actors themselves.
Got it. Excellent. Great. So Rob, I'd just like to turn to, you're kind of one of those kind of gamekeepers turned poachers that used to be on the regulatory end of the scale and are now obviously advising clients. Could you share a little bit about the wider European regulatory landscape, in respect of ransomware incidents, and maybe share some examples of challenges, opportunities, good practices in helping clients?
Sure. And I mean, look, the first thing to remember is that and it may not always seem this way, but regulators are human beings, and so like all human beings, they have reactions to particular ways of behaving. And you can help manage that regulatory reaction by the way that you approach the regulators in the first place. The EU sort of UK dynamic that's going on at the moment, all of the different regulators in the EU, the issue that you have there is no regulator likes to be the last to know, or even the second to know about things. Now, of course, in the EU, you have a one-stop shop for these sorts of issues, but that does not stop other regulators trying to pile in and join the party. So we had a particular case recently where out of nowhere, one of the Spanish authorities decided they wanted to pile in and ask a load of questions around what had happened. And we had to sort of fend the Spanish off by saying, well, actually, this is not really any of your business because it's actually being reported somewhere else. So, the fact that there's a one-stop shop in Europe is helpful, but it doesn't stop other authorities sort of trying to sort of slightly muscle in or at least ask some searching and probing questions. And it is really important that you go to the right place and that you're not seen to forum shop. So that there are some regulators who we know are more litigious than others. There are some who are more active than others. I mean, just to give you an example, who knew? But the Polish regulator, UODO, tends to be quite active in dealing with cyber incidents that are reported to it. But what you can't then do is to forum shop and say, well, actually, I know we're actually mainly based in Poland, but actually I'm not sure we really want to be reporting in Poland. Thanks very much. We'd rather report somewhere else. You have to be very, very careful about how you characterize why you're reporting, where you're reporting. And there is some guidance that's been issued on that out of the European authorities.
Yeah, and it does sound, again, as a non kind of legal person, there's obviously quite a few different regulations out there in Europe, the NIS regulation, the GDPR itself, there's industry-related regulators like the Financial Services Authority or health authorities and others. So again, trying to navigate all of this whole host of different regulators and who to report into, how to prioritize and make sure that you don't fall foul of any of them, can introduce an additional level of complexity into these.
It does completely. And not only that, you have to think about what each regulator is really interested in. So take the financial services regulators, for example. Yes, of course, they're interested in the incident, but what they're really interested in is what's the customer detriment, for example. Yeah. Have you exposed a load of people's bank details and do they need protection from that? Now, that's similar to what the data protection regulators are interested in. However, they come at it, the data protection regulators, from a slightly different angle than the financial services regulators. So when you're tailoring your communications, and one of the things that Amelia was talking about earlier was pre-planning, one of the things you need to have is a communications plan right up front, right out of the gate, that says, this is how we're going to approach it. These are the lines we're going to take with these various regulators. And what you then start to do is to nuance those messages to make sure that you hit I don't want to characterize it too simply as the buzzwords, but that you hit the issues that those regulators are going to be most interested in when you're communicating with them, and that you do so in a way that is proactive where it can be. And I think that's important. So the financial services regulators in the UK, for example, require proactivity of communication at all times. Yeah. And so you don't want to get off on the wrong foot in relation to those sorts of discussions.
Excellent. Thanks very much, Rob. Amelia, do you have any kind of tips to share in terms of engaging with regulators on some of your international engagements? I guess you'd have a strong US presence with it, but feel free to share.
An important thing to remember is kind of the basic point that these incidents are often reportable to regulators, even if no data was stolen, even if no data was released. Back to the point about, having the appropriate logging, if you can't show that this data was not accessed, then you need to do a risk assessment and figure out and assess whether or not the criminals had access to the data, because that itself is going to be a reporting obligation in many jurisdictions. And, even if you have clarity and you know that it went out the door and the criminal promises you that they're going to delete it, you don't get to believe the criminal. The regulators aren't going to. They're not going to say, oh, you paid them off to delete it. Well, surely there's no harm, so it's really fine if you don't notify. That's just not going to fly. So you're going to end up having to, you can tell people that, you can say that you took steps that you hope mean that there won't be any downstream risk to the individuals. But ultimately, those are steps you take, keep your eyes wide open, knowing that, you're not buying off your public notification obligation by doing that. Perhaps you're lowering risk to the individuals, but that's about it.
Yeah, and just to add to that, I mean, the other thing I always say to my clients with relation to regulators in particular is, how they respond is quite often a reflection of how you approach them. And so when you approach a regulator in a very constructive way, what you tend to get in the EU and the UK, at least I can't speak for all the American regulators because some of them are more punchy than others, but what you tend to get in the EU and the UK is a fairly constructive response, in the sense that they recognize that this is not a zero failure regime. Things are going to happen. And so much of what they then want to do will depend on how much trust they have in your ability. And this goes back to Emilia's point, in your ability to do the right thing. And in a situation where you've paid, the criminal has said, right, we'll give you the data back, it's all fine, we'll delete it, no problem at all. One of the things you have to think about is it credible for us to take that view when talking to a regulator about this or not? And it's a difficult conversation to have with them. But if you set it up on a sort of the relationship on a cordial basis rather than a combative basis from the start, that can often be very helpful in allowing you to have those conversations.
Going to them and saying, this is maybe a marginal incident. We don't think there's harm, but we're telling you anyway. Of course, always works better than the opposite, which is that it comes back to bite you when you said, oh, well, I took the technical position that we didn't have to notify you. It's unfortunate, in the US, we've got a lot of wall of shame regimes, right, where everything you report goes, not only what the fact that you had a breach goes public, but everything you told the regulator and the initial communication goes out. So that really makes a lot of those communications very difficult. And we have to advise our clients that they can't say all the things that they would say in confidence and have to leave that to a later communication. And so that goes into the calculation as well. But yes, generally speaking, we don't rely on, for example, the harm regimes in most US laws because they've already decided that a notification event involves sensitive information. So unlike kind of the EU and the UK, where you're doing a holistic harm analysis and you might decide not to notify based on that, we just very rarely do it in the US and tell them and then convince them that there's not really much harm or reason to take further interest.
Excellent. Yeah, I mean, this whole concept of the harm is an interesting one, when discussing with clients to pay the ransom or not. And, there's certainly a strong argument that if paying the ransom means that certain data is not going to be disclosed and that actually protects the individuals, then it may be the right way to go, which the regulator would actually be very happy that you've paid. But I don't think they would ever admit to that or make those kind of suggestions.
No, and this is where these two regimes that we've just been talking about, the sanctions regime, for example, and the information regime sort of collide in a way, because I think you're right. You're unlikely to get a regulator saying, "Go on, pay the ransom." Might as well. They don't normally do that. They leave that decision to the firm. But what you do then have is a regime in which paying the ransom can be helpful in some respects, and another regime in which it's a criminal offence. And so running a path between those two things and taking a judgment as to what the right thing to do is in those circumstances. And of course, some of that is bound up in how serious the issue is, what's the impact on the business of the incident. But that is a really important thought process that we quite often have to sort of help our clients work through, because the way these things interact is not altogether straightforward.
Sure, got it. Great. Well, thanks very much. I'm going to kind of shift our attention to the kind of science bit of the talk, which is getting under the hood a little bit on some of the trends that we're seeing on European ransomware attacks. I'll give a brief overview of some of the things that we're seeing, and then please can you chip in Bruce's Brett's absence. Certainly at least half of the incidents that we've been dealing with in the last 12 months have been ransomware attacks. We have found that there has been a very strong shift in tactics from just pure locking the data and locking people out of the data to the data exfiltration tactic or approach. And then asking clients to pay so that they can get their data back, but also that their data doesn't get disclosed. And interesting, the experience we've had with a lot of companies here is that in most cases they can recover the data. There have been some disastrous situations where the hackers are getting in, they're changing firmware, they're deleting the backups. But in a lot of cases, people are using technologies that are what we call out of bound or out of band backups that don't rely on the Microsoft networking protocols, and that saved a lot of businesses. But when it comes to that data exfiltration scenario and the disclosure, that's when a lot of companies are still and have made the decision to make a payment to keep either their client data or their business partners' data out of the press, effectively. Increasingly, we have seen a kind of triple extortion attack taking place as well. And what's happening here is that the threat actors are actually making contact with individuals inside the company and making threats. We had a bomb scare threat on one client, but also blackmail threats if action is not taken. And that again, that shift or that additional pressure that's been applied to individuals in the company is a worrying trend, because up until now it's been a fairly the victim is the company or the data that the company has, but not necessarily the individuals working for the company. So we're going to have to watch that. We've also seen that most attacks are taking place. The kind of vector of the attack vector is either through a phishing email, which the user clicks on a link and that downloads a piece of software, which then explodes and goes through the network, or there's been an entry point via VPN, virtual private network, where the technology hasn't been patched, or credentials have been sold online on the dark web. But those two avenues seem to be the common ways that the guys are getting in and staying inside the environment. And another trend that we've certainly jumped on again over the last 12 months is leveraging threat intelligence to help inform us about how best to react and respond to the incidents. So in the old days, you might have to go and image a whole lot of computers around the network, do a proper image so we preserve the evidence, and it can take sometimes days to collect all the data, get all the images, to only then find out who the bad actor is or what kind of malware was on the system. Whereas by combining threat intelligence early in the investigation, we're able to take a few snippets of the ransomware notes, look at the Bitcoin address that's been provided, look at the dark web address where the threat actor is communicating from, and use all of that material to help us form a picture of who the threat actor is, who they might be, how likely are they to pay, so how likely are they to provide the data or delete the data if they're paid, how negotiable are they, we kind of all use that as a tactic and technique of trying to improve the efficiency of response. We've also been deploying endpoint monitoring technology to help contain the incidents quicker and get visibility across the environments, much faster than, and I think there are a number of providers that are doing the same thing. than again shutting everything down and trying to piecemeal, build a network from scratch again. But yeah, very interested in both of your thoughts and experiences on some of the things that you guys have done. Are you seeing threat actors are the same guys? That it seems a bit random as to whether they're targeting US or European, victims. In a lot of cases, we had a lot of Keyser. We had a lot of Hafnium attacks here. Some Revel attacks as well. So it doesn't look like there's a concerted strategic effort to go after particular assets. It's basically quite a free for all at the moment, because people are scanning companies' external infrastructures en masse, and then wherever there's a vulnerability, that's then potentially being bought on the dark web by somebody who then uses those credentials to break in. But it's been fairly random, certainly for ransomware. We have seen quite a lot of targeted attacks, still nation state targeted attacks, and are responding to those, specifically for IP theft. But for the ransomware, it's a bit like that. And Rob, I see you nodding your head, so maybe I'll point to you first.
Two things, Ryan, and that's kind of reflects partly what we're seeing. Two extra bits, I think, from my perspective. The first is third-party outsourced providers.
Yep.
And the potential weaknesses that come from those. That's particularly important in all sectors, frankly, but also in the financial sector, where that's something which is a real potential vulnerability. And I think there's a sort of interesting question about how much firms really understand about the strength of the networks of the people to whom they outsource critical functions. And that's a really important area that we need to look at. The other thing is, and it just picks on a point that you were making about the exfiltration versus just encryption. What we're increasingly seeing is threat actors, how can I put it, sort of lounging around on the systems for a while before they actually press the big red button, to allow them to understand where all the data is and to take out the data that they want to take out, and then pressing the big red button at that point. And so we've seen examples where the threat actors have been in the systems for some weeks, if not some months, just gently working their way around the network to see where everything's stored, so they can take stuff that's really valuable rather than just taking a big dump of everything. And that's obviously an important part of that whole process.
Excellent, thank you very much. And that often echoes, when we're doing the forensics, we are going back months sometimes before we get to the place of the entry point. And it is interesting that the threat actors are so bold, if you like, to stay in the environment for such a long time before pulling the trigger. But that gives us opportunities to disrupt the attacks. And there are warning signs, hard drives that fail, backups that are not working properly, the extra users that get created. The regime of getting people to monitor and be more vigilant is still very much there. Amelia, I know you've responded to several international events as well. Anything else to add?
Yeah, a couple of points kind of building on what Rob had said. It's kind of war stories a little bit. So, on the third party point, the Acelion breach hit a wide swath of people across the world. And, it was a product designed to transfer sensitive data. So that was right in a lot of companies' sweet spot. But, we had one of our clients where, the ransom request didn't go to them. It went to some employee, not even necessarily affiliated with their company. So they were not really understood to be part of the event from the attacker. There's a lot of this there's so much going on that they don't necessarily, they're not paying attention to everybody. They've got what they've got, and they don't, they're not targeting. What they did eventually do when they realized that their ransom request that had gone awry wasn't answered is they did go through the data and posted some of the really sensitive stuff and profiled that, which caused a PR nightmare for the client. And they were never quite sure if they'd found the other cache of sensitive data that was in there somewhere. It was a little bit hard to find. And so that was its own kind of interesting PR issue, again, with the kind of walls of shame we've got in the US. So disclosing what was there was a little hard. But all of that goes to kind of the points about knowing where your data is, minimizing it and whatnot. And then another point, we've been called into ransomware attacks, I feel like more recently on kind of large scale attacks where data was exfiltrated that's not necessarily PI, where it is third party contractually protected data. And the contracts are all over the place. So, as the tip to those in the audience is to think about, which is your position? Are you the one who's got the platform and you want your contracts to be relatively protective about not having to tell everyone immediately everything that's happened, or allowing them to terminate the contract, for example, or the opposite. If you're in a position where you want to know right away and you want as many rights as you can. I mean, they vary tremendously. And not only is that complicated to deal with, at the time, it's very expensive and hard to figure out what you're going to do with your 500 clients if their contractual obligations are all over the
map. That's an extremely good point. And certainly on the third-party side, I know we've spoken right at the beginning about planning. I've been in quite a few situations where clients are doing an incident response, but they're actually doing it with the data's been lost through the third party and not through themselves. And so the incident response plan, the IT, all of that stuff is out the window because it's actually the third party that's been breached. And to that point, we actually work with quite a few law firms directly, helping their CISOs and functions. But we have had some situations recently in the UK where barristers' chambers have been hit by ransomware, and law firms have had to go and work out what data has been lost and effectively try and manage this incident where you've got client data that's being leaked through that process, but you don't really have as much control as you would if it was your breach. So there's quite a lot to think about there.
Yeah, and this really comes down to scenario planning, right? Effectively saying actually where are our points of biggest risk here, and it's not just somebody coming in through a back door in your own systems. You've got to really think about your ecosystem of suppliers to see where the risks arise, and work through what we would do in relation to the key risks that arise in that context.
Yeah, I agree. So we are just looking at questions. We've actually got one of the first questions that's come up is around the privilege that we spoke about earlier. So Amelia, perhaps you want to talk about this one. But, what can you provide some tips on ensuring that reports remain under privilege?
Sure. I mean, the gold standard, as defined by the courts, is not, I will admit, not entirely realistic. But the idea is that your outside counsel retains a vendor who is not otherwise working for the company, doing IR or doing security assistance, to come in and write a report, if anything, purely to assist counsel, and that there is a second track investigation that is handling your business obligation to investigate the incident, and that is not privileged. And so it's a difficult line to draw, but that's what the courts are saying that they expect to see, is that the investigation for the purpose of litigation or for the advice of counsel is a separate track, and that can remain privileged, but they acknowledge there's a business need to investigate. And so if the only investigation is being done by the lawyer, that itself is causing issues as well.
Okay, thank you very much. So there are two other questions. One is in the open chat, which I think maybe we could respond to during the next session, because I know we're wrapping up. And then I think the second question is the cost of information security and privacy something that consumers need to be aware of and be willing to pay extra costs for. And I think that is true. There is a price to good security, and I guess the market will define those companies that protect people's data and those companies that don't. Consumers will make decisions about that. It's the same with products. People buy products in the long term that probably will be more secure than those that aren't. and hopefully we'll weed that out. I think regulators can play a role in this as well to help ensure ensure organizations actually do the right thing about security. But yeah, at some point we definitely will. There is a cost, and unfortunately, we'll probably be part of those that actually end up funding those costs.
I think there's a conversation to be had about that hasn't yet been had, actually, which is, to what extent is an average consumer prepared to pay more for a greater level of security than they would otherwise pay? And we see from all the various data breaches that there have been that people start saying, well, I didn't realize that my data was going to be used in this way or that way or the other way. And the reality is we know that people don't really engage with that on a particularly sort of deep level. And so there is a conversation, I think, that's going to have to be had in the future around exactly what we are paying for and what we're getting for our money in that context. Yeah. And decisions, but consumers need the information to be able to take those decisions in an informed way. And I don't think we're there yet, anywhere near there yet, actually.
And I think it's that kind of cost-benefit analysis that companies go through as well. Is it worth spending the extra money to protect the information that you have? And you can make that decision if it's your own data. But when it's not your own data, that's where GDPR is coming in, or the CCPA, to say, actually, guys, if you're holding this data, you have a responsibility. So yeah, very interesting. I'd like to thank, I don't know, Bruce, are you going to do the thanking? Because I know you wanted to wrap things up.
I'd love to do the thanking.
Please go ahead.
Okay. Well, thank you, Ryan. Terrific job, Amelia, Rob. Thank you guys for a great and very important panel. We have one panel left today. It's a regulatory spotlight, meaning a one-on-one conversation where we'll get insights from Ireland's Data Protection Commission. That starts at 5:05, so we'll see you back here in just a few minutes. Thank you.